Please be seated. Let's go ahead and get started on council ready at 8:30. Let's get started. All right, good morning. Do we have a corporate?
Yes.
Okay, good morning, everyone. Let's go ahead and get started. Good morning, everyone. This is Alert Towing versus Bradshaw. Both sides here?
Yes, Your Honor.
Oh,
I'm here for the Sheriff's Office.
All right, good morning, everyone. We have a court reporter if you'd like to state your appearances for the record.
Good morning, Your Honor. Jessica Butler on behalf of the Palm Beach County Sheriff's Office.
Freddie Rhodes on behalf of the plaintiff, Alert Towing.
All right, good morning. It's nice to see both of you. We're hearing a motion to dismiss. Council, I had a chance to read your motion. Would you like to make additional argument at this time?
Yes, Your Honor. Just to give you a brief factual background, what this is the plaintiff is a towing company. They do not contract directly with PBSO. Rather, they agree to follow certain rules and regulations in order to be placed on the towing rotation list.
Okay, I read your motion, I read the complaint also. Let me just ask you, what does plaintiff fail to allege, or what elements of the causes of action are not on the face of the complaint?
Well, Your Honor, he doesn't allege that this is a written express contract. The elements of a written express contract.
Is that required?
Yes, Your Honor. There's case law. The case law that I cited you indicated that if it is not a written express contract, then the sheriff is barred by sovereign immunity.
Okay.
Sovereign immunity is only waived through a written express contract.
That sounds like a great argument, but it might be more appropriate on summary judgment, potentially. I think because sovereign immunity is a legal determination I have to make, and that's something I would have to decide as a matter of law. So I think your arguments are excellent, but I think they might be more appropriate potentially on a summary judgment.
Your Honor, I would just say that the contract or the alleged contract that they're claiming the rules and regulations are attached to the complaint, which I think would allow you to review the contract and make that
No, but I can't make a legal determination, because remember, the standard still on a motion to dismiss is everything they say I have to take as true. So, but I can't make a legal determination that it's not under the theory of sovereign immunity. It's not a contract that would be sufficient to withstand that and hold the sheriff liable. Again, great arguments, but I think more appropriate for a summary judgment. Let me hear a response.
As far as for Your Honor, I think you're understanding exactly where I was going to be coming from, which is they're asking you to make determinations about the actual agreement itself,
Legal determination.
which is the four corners. They're in essence saying what the plaintiff just alleged, which we said is an agreement, is true. Well, if it's true, what are we doing here? That's the problem. And it's interesting enough, the reason why it's also attached is right in their own the contract. They spelled out saying this agreement. They're saying it's an agreement right in their own language of the contract, and it says it multiple times.
Okay. Okay.
So.
Okay, here's what I'm doing. I'm going to deny the motion to dismiss. I'm going to have you answer the complaint. How much time do you need to answer?
20 days, Your Honor.
Okay. 20 days, okay?
Oh, that's fine, Your Honor.
20 days is fine, and I'm going to invite you to allege these arguments. If you want to take a deposition, that's fine. If you just, this is a legal determination. If you simply want to file a standard motion for summary judgment, you're more than welcome to do it.
Thank you.
All right, thank you guys. Great work, both sides.
Thank you, Your Honor.
All right, we have case management conferences this morning. I'm going to go ahead and call them out, and then we'll do our UMCs. First case management conference I have is Wells Fargo versus Sasser, foreclosure case, Wells Fargo, Sasser. No, sure. HSBC Bank versus Garcia.
Yes, Your Honor.
All right, counsel ready? Good morning. All right. Are you Mr. Garcia?
Yes, please.
All right, good morning. All right, this
Good
is HSBC versus Garcia. What's the status of the case?
The case is post-sale, Your Honor. The defendant filed a motion to vacate the sale, which we cross-noticed for this morning.
Okay, I read your motion. Would you like to make argument on your motion, sir?
Yes, Your Honor. Due to you couldn't be here that day on the second, right? So,
But the sale's gone through, so why should we vacate the sale legally?
because I think my rights have been violated here. The other judge, the Honorable Curley, didn't have all the facts to make a sound decision.
Okay.
Okay, and
Well, what's missing legally?
legally that I show that I can make payments to the bank.
That's great. I
Ready.
mean, you can set.
We're ready. And then he said a conference, but then the bank is just based
Okay.
themselves to be on the past. I'm telling them,
But you
listen.
didn't pay, this has been pending since 2014. So
Okay.
the mortgage hasn't been
But-
paid in how many
But the
years?
thing is that they are the one stopping the bank, the servicing bank, which is Mr. Cooper,
Yeah.
from finishing it. They need like 60 days. I submitted all the documentation.
They're not, I can't make them accept the settlement, sir. You haven't paid your mortgage in over 5 years.
But I'm willing to pay whatever is behind, whatever.
The problem is I can't make you settle.
They are the one tricking the whole system, Your Honor.
Here's what I'm going to do. I'm going to deny your motion to vacate, but if you have your argument to mediation,
Yes, and in fact, Judge Curley, as part of setting this, sent us to a telephone conciliation conference, which led nowhere.
so I can't make them accept this.
Your Honor, I show that I was missing one document because the bank was
I
taking
know, but I don't
forever.
have the legal authority. I cannot make them accept this. The bank has already said, no, you haven't paid your mortgage in over 5 years, sir.
But I'm willing to pay. I offer
They
them
said that's not good enough.
different scenario,
They say
different
that's not the right
offers.
amount of money that they need. So the motion's denied. Thank you so much. The motion is denied, Michelle, case closed. Carter versus Goldman Sachs. Anyone here on Carter versus Goldman Sachs? No? Ferguson versus Vizzy. All right, good morning, council.
Good morning, Your Honor. I have a number for the opposing counsel.
Yeah, what's the number?
It's 561
Okay.
213
Okay.
3959.
Hello?
Oh, council, good morning, this is Jim Sasser. I'm calling you on Ferguson versus Vizzy. Are you ready for the status conference?
Yes, good morning, Your Honor, thank you.
Wonderful. What's the status in this case? I know we've had some recent hearings.
Yeah, we have had recent hearings. This was consolidated with another matter. We are moving forward on discovery together. We've been working well on that, and we're trying to set a mediation together, so.
Wonderful. That sounds great then. So we'll do a 90-day status conference.
Thank you, Your Honor.
Excellent work. Thank you, guys. Have a great day.
Thank you, you too.
Ramirez versus Oxidine? Anyone here on Ramirez versus Oxidine? Pirangello versus Santa Maria? Pirangello versus Santa Maria? Jones versus Malley? Okay, come on up.
Good morning, Your Honor.
Good morning.
Frank Lotney here for the plaintiff, Connie Jones and Forrest Jones.
Wonderful.
Your Honor, we also have a motion for mediation today.
Okay,
Your Honor,
wait, let me hear from defense counsel. Just state your appearance. Go
we
ahead.
here on behalf of the defense.
Good morning. Nice to see you both. You said you have a motion for mediation?
Yes, Your Honor, this is a 2017 case. Your Honor, we've been trying to set this mediation since January. We send them dates. They don't respond. A couple weeks go by, send them dates again. Everything has been done. The only thing is, I'm afraid to set it for trial because I'm afraid we'll get into a jam if we can't get it set. We've been having trouble setting.
If I send you trial order, it'll have a mediation requirement. Trial order always has that. When would you like to go to trial?
Your Honor, I would like to set it at the end of the summer, but I would like to set it for mediation within 30 days because everything's done.
Are you ready for mediation within 30 days, or do you need to do more discovery?
We're all set, Judge. It's just a matter of my schedule, and
Not a problem.
so
Why don't we do
I would
this?
ask for longer than 30
I'll do
days.
60, if that's okay. That'll give you more time. So we're going to send you set up for trial, Michelle, in August.
Okay.
And then that'll have a mediation deadline then.
All right, thank you.
Thank you, guys. Have a great day.
Thank you.
All right, Geico versus Bolden. That's right? All right, good morning.
Yes.
All right.
Judge, in this
Yes.
case, we have a motion to compel discovery set for April 30th.
Okay, that's fine. So you want to see you on April 30th? Do you just want to do the motion at that time?
Yes, Your Honor.
Okay.
My client is considering filing for bankruptcy, so...
When are they going to decide whether, because then the hearing will be off, when are they going to file?
He has been going on and off and writing documents and everything.
Okay.
We expect that to happen within the next maybe 30 days.
Okay.
But I'm not sure.
But we still have a meeting, we still have a hearing in April.
Yes, no,
Okay, that's
we will
fine.
be here.
Okay, not a problem. Just email us if your client decides to file for a bankruptcy, and then the hearing will be off, otherwise we'll see you at the end of the month.
Okay, Judge, do you want anything on the
No,
order?
you don't need to worry about that.
Thank you.
Thank
All
you, Your Honor.
right, Ramsey versus Baker. Ramsey versus Baker. Termillis versus Universal Property. All right, good morning, counsel.
Good morning, Your Honor.
All right, good morning. What's the status of this case?
Your Honor, defendant responded to complaint and requested discovery, this exchange discovery. So
Okay.
there's nothing really pending right now.
Can I set you for trial? Meeting's closed?
If wants that, Your Honor.
Well, we need to set it for trial,
Are they
so.
present, Your Honor?
They're not present. So if the plaintiff's not present, were they going to be here?
I don't know.
Yeah, okay, the case is dismissed then. All right, Ellis and Jerome versus Universal. Okay. All right, good morning, counsel. Are you expecting the other side?
Yes, ma'am.
Okay. Do you represent plaintiff or defendant?
Defendant.
Okay, case dismissed. Floyd versus Johan. Floyd, counsel ready?
Plaintiff here.
Okay, wonderful.
Defendant's attorney, defendant, they don't have an attorney, but they spoke with him last night. I said I'd represent him, that, I talked to. He would like to reschedule the conference for 30 days.
Sure, fine with me. We'll send,
okay?
yes, perfectly fine. Michelle will send you a new order for 30 days.
Thank you very
Sounds
much.
great. Have a great day.
You too.
We just did Floyd versus Johan. Moore versus Geo Group. Moore versus Geo Group. Rivera versus Franco. Rivera versus Franco. Mahecha Gavria versus Krieger. That's right, Mahecha Gavria versus Krieger?
Yes.
All right, good morning.
Good morning, defense counsel for Peter Joseph Krieger.
Okay, good morning.
Plaintiff's counsel Scott Colson.
Wonderful. What's the status of the case, guys?
Basically, my client's out of the country, so we're trying to get him here for depositions and CMEs, and that's kind of our delay right now.
Not a problem. Can I set you 90-day status conference? Would that be helpful?
Yes.
Okay, 90-day status conference it is.
Thank you.
All right, thank you, guys. Zabriskie versus Zeman. That's ready? Zabriskie, Zeman? All right, good morning. All right, good morning, counsel. And what's the status of this case?
Good morning, Your Honor. Neil Cherry, been for defendant and counter plaintiff, George Zeman. I don't know if opposing counsel is
They're
here.
not here, and I'm going to dismiss it, but you have a counterclaim. That's no problem. I can't dismiss it with a counterclaim pending.
Correct, Your Honor.
Okay, all right, so we'll do, well, they're not here. What's the status of the case?
Pleadings are closed.
Okay.
Discovery is ongoing. There's
Okay.
been preliminary discussion of the mediation.
Okay, can I set it for trial?
I would like to set it for trial. My client is in Mexico for large parts of the year, so
When do you want to go? I'll set it whatever you want.
I would prefer to confer with him first.
Why don't you send an email to your client, email Michelle, we'll set it whenever you want to go to trial.
Thank you, Your Honor.
Perfect, thank you so much. Edelstein versus Courtyards in City Place. All right, good morning. All right.
Good morning, Your Honor.
Good morning, guys.
Good morning, Your Honor.
Good morning. What's the status of this case, guys?
Working on discovery, getting deposition set.
Excellent. Do you guys, are you at issue doing trial date or do you want to wait?
I'll follow those when we're ready, Your Honor. I think we're just
Okay, that's fine, counsel.
I think we prefer to wait on trial. I think we're still ongoing with discovery, trying to set depositions.
Not a problem. So let me do a 90-day status conference for you guys. All right, thank you guys.
Have a great day.
Thank you.
Stabbing Holdings versus First Protected.
I'm on that one.
Okay.
How do you have a phone number?
Wonderful. What's the phone number?
It is 678
Okay.
777
777
8447.
8447. Got it. Okay, let me give a call.
Jackson D'Souza.
Counsel, are you ready on Stabbing Holdings versus First Protected?
Yes, Your Honor.
Wonderful. Good morning. Opposing counsel's here in the courtroom. Can you state your appearance for the record? We have a court reporter.
Thank you, Your Honor. This is Karen Coles, representing First Protective Insurance Company.
Wonderful.
Jackson D'Souza, representing the plaintiff.
Wonderful. What's the status of the case?
Your Honor, there's only one pending matter, which is the motion for entitlement to fees.
Okay. Can we set that for hearing?
Yes, yes.
Okay. We need to set the attorney's fees motion for hearing. Is that okay, counsel?
Yes, ma'am. I just couldn't hear opposing counsel.
Yeah, not a problem. And do you want to go online and set that for hearing?
Yes, Your Honor.
Wonderful. And that's just entitlement, not amount, right?
No, just that.
Just entitlement. That's fine. So that's not evidentiary. You can go ahead and set it for hearing then.
Thank you.
All right. Thank you guys. Have a great day. Oh, yes.
Judge?
Yes.
Your Honor, entitlement's been decided, so the hearing should be only about amount.
Okay.
Okay.
Oh, that's even easier for
In
you.
which case, I'll
It will be
set it
evidentiary.
evidentiary.
Set it as an evidentiary.
Thank you.
All right. Wonderful. Thank you guys so much. Have a great day, everyone.
You too. Thank you.
Segura versus Florida Peninsula. Segura, Florida Peninsula. Okay. All right, let me start. I have any more case managements? I have to go back and do Carter versus Goldman Sachs. Anybody else here for a case management conference? Otherwise, I have to do you. Come on up. Which case you here?
Diane Jimenez versus Citizens.
Oh, yeah, okay, good. What is the status of that case?
Your Honor signed an order of abatement yesterday.
I did.
The appraisal.
Okay, perfect, yeah, we have it here, and that's, abatement's been signed, and that's perfectly fine, and you guys can go to appraisal then. Wonderful, have a great day. All right, let me start UMCs then. Buckner versus Loudspeak Co. of Florida, motion to continue.
Ellis Pettit on behalf of the plaintiff, Kim Buckner. Opposing counsel reached out to Mr. Pericuzzo indicating he was late. I don't know.
Oh, okay, we can wait a few minutes, not a problem.
Okay, thank you.
Not a problem. All right, I have an emergency foreclosure case, Chase Home Finance versus unknown tenant. The plaintiff here, the defendant here, he's the one who filed the emergency motion. Is Mr. Sandville here? No? Plaintiff here? All right, no show. Christopher Morera versus Schneider, please. Motion for partial summary judgment. Okay. All right, Councilman. Good morning.
Good morning, Evan Rosenberg, on behalf of the plaintiff.
Yes, good morning. This is your MS, this is the MSJ, and I read the entirety of the MSJ.
Yes.
Everything looked to be in order. Would you like to add anything to the MSJ this time?
No, Your Honor, the only thing I would add is that the summary judgment is based upon the failure of the defendant to file an answer as to those two counts. So.
Yeah, no, you're exactly right. I read it, and I'm going to go ahead and grant it for you.
Thank you. As to...
well, it's actually going to be partial summary judgment, right?
Correct. And I guess my issue is that it's going to be the liability. I guess we'll have a separate hearing.
We have to have a separate liability, and it's liquidated or unliquidated?
I believe it's unliquidated, Your Honor.
Okay, if it's unliquidated, then we can go ahead and take care of that event.
The other issue, Your Honor, is I do have a separate final judgment for the quiet title portion, if that's okay.
I'll take that sign. Just hand everything up to the bailiff.
Thank you, Your Honor.
Wonderful. Have a good day. All right. Let me go ahead and do Portisol Homeowners versus Deo, please.
I'm here.
Counsel, the other side's telephonic. Let me give him a call. All right, good morning, everyone. We have a court order, and we're trying to get counsel on the phone.
Good morning, Caitlin de Rivera.
Good morning. I'm trying to reach the attorney handling Portisol versus Deo, please.
And your name?
Judge Sasser.
One moment.
Thank you so much.
This is Gerard Collins.
Oh, Gerard Collins? Okay, wonderful. I'll get him on the phone.
Good morning, this is Jerry Collins.
Oh, good morning, Mr. Collins. This is Jim Sasser. I'm calling you on Portisol versus Deo, and opposing counsel here in the courtroom. We have a court reporter. If all counsel could please state their appearances for the record.
Earl Mallory for
May it please the court, Gerard Collins for the plaintiff, Portisol Homeowners Association, Inc.
Earl Mallory for defendant Deo.
All right. Good morning, everyone. This is actually defendant's motion to reset the special set hearing, and Mr. Mallory, I read your motion. You may proceed.
Yeah. Pretty much, this is an HOA trying to divest a homeowner of 4 dogs. The court's already ruled there is no emergency here.
Okay.
We've answered the
and I'm happy to set the hearing. Though it's not an emergency, but I do need to set the hearing. So how much time do both sides need for the hearing?
Well, he says he needs 2 hours. He's disclosed that he's got 5 witnesses. Okay. I need to be able to depose those witnesses.
So let me ask plaintiff's counsel, how many witnesses do you intend to testify at the evidentiary hearing?
I think we would have 5 witnesses, Your Honor.
Okay, wonderful. Can you make those witnesses available for deposition?
Of those 5, only one is my client.
Okay, so he's gonna have to
to a very large extent, I don't have control over those people. They have, because of the seriousness of this issue.
No. I'm going to set it for hearing. No. I'm setting it for hearing next week. What I'm going to do is I'm going to set it for hearing next week. Michelle will give you, if you email Michelle, she'll give you the date and time. I'll give you the 2 hours next week then. But you have to make your client available for deposition, and opposing counsel has to have an opportunity to take the other witnesses.
And I need to have disclosure of who
do you have the names
witnesses
of can you send by 5 o'clock today the witnesses you intend to call at the evidentiary hearing? I'm happy to expedite the evidentiary hearing for you and give you the 2 hours requested, but you have to disclose your witnesses to opposing counsel in advance.
By 5 o'clock today?
By 5 o'clock today.
And Your Honor, if the witnesses fail to show for their subpoena, can they be excluded from the hearing?
Yeah, you need to go ahead. Yeah, the witnesses have to show for subpoena for deposition.
Okay.
Otherwise, they will not be testifying at the evidentiary hearing.
Okay.
Perfect.
And as far as documentary evidence?
Yeah, are you going to intend to have any exhibits? Can you please go ahead and just share an exhibit list also by 5 o'clock tomorrow? And then you can meet and confer to share exhibits in advance of the evidentiary hearing also.
Okay, so by 5 p.m. today, the witness disclosure, and by 5 p.m. tomorrow,
The exhibit list. Yeah, and I'm happy to expedite this. I understand the seriousness of this for the homeowners association, so I'm gonna get you guys in for 2 hours next week.
Okay, so the hearing is off for tomorrow then?
Yeah, it's all for tomorrow because he wants to do discovery. It's only fair to defense counsel to be able to do discovery in advance of the hearing.
I understand, Your Honor.
Okay, that's fine, but we'll get you all in next week after you guys do discovery. I will send you whenever you want. Just email Michelle the dates that work for you.
Okay, thank you
Wonderful.
very much, Your Honor.
Thank
And I'll
you.
send you a proposed order.
Wonderful.
Okay,
Thank you guys.
Judge.
Have a great day. All right, let me do some foreclosures, guys. Let me go ahead and do Wells Fargo Bank versus Belcoal, please.
Yes, Your Honor.
Council ready? All right, so defendant's motion to dismiss. Is the defendant here?
Your Honor, we have an agreed order
Oh,
denying it 30 days to answer.
Not a problem. Just hand that 30 days to answer.
Thank you.
That's fine, 30 days. It's 2018, but that's fine. Okay. All right, Wilmington Savings versus Unknown Heirs. Motion for defaults. All right, good morning. All right, this is Wilmington versus Unknown Heirs. It's a plaintiff's motion for sure judicial default. And I read your motion. Anything to add?
Nothing, Your Honor. I have no objection. We represent the defendant who filed.
All right, I'm going to go ahead and grant default if you want to hand the orders to bailiff.
Very good. Thank you.
All right, next foreclosure. Deutsche Bank versus Pierre Lewis. Motion to cancel and reset.
I have that one.
Okay. Motion to cancel, come on up. All right, good morning. Good morning. This is a motion to cancel and reset. And when do you, this is defendant's motion, so you may proceed. And you said they filed a motion for rehearing, and the rehearing, I think, Michelle, is that the one that I denied already? That's, or this one, this is Deutsche Bank versus Pierre Lewis. Yeah, Michelle's gonna look at it. Okay, that's fine. There's a couple I denied already.
I think it's the.
Yeah, I believe it's so. Okay, that's fine then. So we'll wait then. So we have you guys, we'll send you an order on the motion to cancel.
We have no objection.
Okay, that's fine. You have no objection to the motion to cancel? Oh, the motion to cancel plan. That's easy. Okay, thank you guys. Have a great day.
I have orders, would you like me to just?
Yeah, motion to cancel. Sale is canceled, and I'll get you an order on the rehearing.
Okay, thank you.
Have a great day. HSBC Garcia, I got another one. HSBC Garcia, another foreclosure case? Oh, I think we did that one already. Okay, so let me go ahead and do,
Your Honor?
Yeah.
I'm very sorry to interrupt you. I was here for CMC,
Which
but I
case?
got here late because of traffic. I'm driving down from Miami.
Sure, what case?
And you already did both of those cases and they were dismissed.
That's fine, not a problem. Just tell me which case.
It was the one ending in 425, Marjorie Jerome versus Universal.
That's fine. Do you represent plaintiff or defendant?
Plaintiff, Your
Okay,
Honor.
that's fine then. What's the status of the case?
The status of the case is at issue. We'd like to notice it for trial.
I'll set you for trial now. How much time do you need for trial?
We would like a trial towards the end of the year.
Okay, we're not gonna wait till the end of the year because this is an older case. We'll set you for trial in August.
Okay.
Okay, that's fine. That one will be set for trial.
And I have another one, Your Honor. Miranda Dermilis versus Universal Property.
Sure, and when would you like to go to trial? Is that one close to?
That one is also at issue.
Okay. Can we set you for trial in August on that one too?
Sure.
August it is. We'll send you both trial orders today.
All right, thank you so much, Your
No
Honor.
problem. Have a great day.
You too, bye-bye.
Okay. Let me go ahead and do Parker versus Universal Property. Plaintiff's motion to compel scheduling of depositions. Counsel ready? All right, good morning, everyone.
Good morning, Your Honor. Plaintiff's counsel had a conflict and asked that we call it.
Sure, what's in the phone number?
224
224, okay.
595
595.
8785.
Okay, let me give him a call.
And this is Parker versus University.
Yep, I have it, yep.
Hello?
Oh, counsel, good morning. This is Jeff Sasser. I'm calling you on Parker versus Universal Property. Are you ready for the hearing?
Yes, I am, Your Honor.
Wonderful.
Thank you so much for allowing me to appear by phone.
Not a problem. This is plaintiff's motion to compel scheduling the depositions. And counsel, I read your motion. Would you like to add anything to your motion?
And no, Your Honor, we're just looking for the depositions, whatever time Your Honor thinks is allowable for me to grant the motion.
Okay, response please?
Your Honor, we feel that it's a little premature. As you can see, she requested the first time April 1st
Okay.
and filed the motion April 8th, which is 5 days.
No, we can wait. When do you think you'd be ready for depositions?
To get the dates from our client, we probably need a week or two.
Okay, that's not a problem. How about we set depositions within 90 days? Is that enough time?
That works
I think
out.
90 days is fair. So I'm going to grant your motion and we'll set the depositions within 90 days.
Okay, that's fine, thank you.
Okay, can you just print an order and email them either way?
Okay.
Wonderful, thank you so much. Have a great day, council.
Thank you.
All right, thanks.
Okay. All right, let me go ahead and do Wilmington Savings versus, again, unknown heirs motion for devolve. This is actually Bigby. Anyone here on Bigby? We might have done that one already. All right, structured settlement. In Ray, this is approval of transfer settlement. This is for a transfer payee CG. Councilor, ready on that one?
Your Honor, I have a phone number. Call Mr. Schreiber.
Yeah, let me give him a call.
You ready?
Yep, I sure am.
954-966.
966.
5600.
Okay, let me give him a call.
Schreiber.
Oh, good morning. I'm trying to reach, who am I trying to reach?
Daryl Schreiber.
Daryl Schreiber, please.
Okay, hold on.
Thank you.
Hello?
Oh, Council, good morning. This is Judge Sasser. I'm calling you on the structured payment settlement. Are you ready for the hearing?
Yes, good morning, Your Honor.
Wonderful. And Council's here in the courtroom along with the client as well. So I've read everything, and anything to add at this time?
No, Your Honor.
No, Your Honor.
Okay. Would you like to state anything to the court? Do you have any questions? Do you understand everything? Yes. Okay, I just want to make sure I'm here to answer any questions if you have any questions about the structured settlement. I just want to make sure you understand everything, and I'm going to go ahead and approve it then. Okay, just hand an order up to the bailiff then. All right, thank you so much. Have a great day, everyone.
Thank you, Your Honor.
All right, sales versus sales, motion for attorney's fees and cost.
Morning, Your Honor.
Morning.
How are you?
Good, how are you?
May I approach a
Yeah.
some affidavits, a motion, it's charged with
Yeah, no, everything's fine. Everything looks great. You did a wonderful
By
job.
the way, one of my really good friends who passed away last year was the first black basketball player to play at University of Virginia, Lamont Carr, and he was on the first ACC championship.
Cool. Oh, very neat.
They did a movie about him.
Wow, what's the name of the movie?
Lamont Carr, Folklore Miracle.
Oh.
Cheesy, but
Oh, no, it sounds like a good uplifting
He's the
movie.
first black basketball player for UVA.
Oh, wow, I'll have to watch it then. Thanks for sharing. All right, we'll send this out to you then.
Yeah, I've sent out. Thank you.
Thank you. Have a great day, Mr. Rose. All right, let me please go ahead and do Jones versus Malley. Anyone here on Jones versus Malley? Let me do Law versus Surgery Partners. Council ready? Both sides here?
Morning, Your Honor.
Morning. Do we have a court order? Yep. Okay. All right. Good morning. Nice to see you both.
Nice to see you.
We are here in Law versus Surgery Partners, and this is plaintiff's motion to compel insurance coverage info from the surgery partner defendants. And I read your motion. You may proceed.
So, Judge, we're a little bit exasperated with what's going on here. Defense counsel has produced what purports to be an affidavit, but it does not comply with Florida Statute 92-525. In fact, the bottom of the document checks off that it was not done under oath.
That's not it.
So that's problem number one. Problem number two is it does not address the fact that the 10K report filed with the SEC still says that there's $35 million in coverage.
Okay.
This only addresses up to a $30 million layer. Now, it may be, because those reports are written very broadly,
I know.
it may be that that's something else,
Okay.
but we just need confirmation of that under oath.
Okay.
And then the other problem that it's created for us is we are set for mediation on Friday, and now we have an excess carrier who has, I don't know, just found out about this case, and what we were required to do is we revoked our prior demand, which was specifically conditioned upon it being all the coverage. We've now made a new demand, and so I don't know if Ironshore is prepared to be at mediation on Friday with
Would
such
you know who
late notice.
represents the excess carrier? Are you representing the excess carrier?
No, Your Honor. I don't represent the excess carrier. I represent the defendant, the insured defendants.
Okay.
With respect to the defect under oath, Your Honor, I believe that this was a procedural.
Can we fix it? I'm sorry, that's
We
not
can
an
fix
issue.
it. Okay.
Okay.
Yeah,
How
yeah.
much time do you need to fix the affidavit?
I'm not having personally spoken to Ms. Baldock. I've spoken to my corporate liaison.
I imagine that I could have it fixed within a day or two.
Yeah, they'll need it in advance of
Yeah,
mediation. And what about the situation with the mediation now?
Well, unfortunately, Your Honor, the mediation has been conditioned not upon just upon this, but upon several other, which I don't want to go into detail because.
Yeah, sure, it's confidential, I'm sure that's fine.
And my client, and I advised the plaintiffs yesterday that we are not prepared to meet all of their conditions to mediate. We are available to mediate on another day. Obviously, this will give us time, we can reschedule the
I'm happy to push it back a week or so, but we don't want to have an open-ended extension.
Well, the other problem, Your Honor, is that the plaintiffs have, one of the unilateral conditions that they said is that they required the presence of only one mediator who's not available in a week.
Oh, okay.
We want to use Rodney Max,
Sure.
Judge,
Okay.
because of the
Yeah.
nature of this case. I mean, we have close to $8 million in just past meds alone.
Wow.
So
Okay.
it's a
It's a
significant
major case. Yeah, it's a major case, okay.
He has provided dates of availability in May and June.
Okay.
I've provided those dates to my client. I would imagine that Mr. Max has provided those dates to plaintiff's counsel, opposing counsel, but we're diligently working on this, Your Honor. I mean.
No, I take it for your word, that's not a problem then. Can we get Mr. Max later on? Can we get Mr. Max later in May possibly? Can we mediate that?
We're willing, we've extended an offer to work on any date in the first week in May,
Okay.
including Saturday, May 4th. Obviously, that's not
It's a holiday, I mean, it's a weekend,
right.
so that's fine then.
But we're available the entire week
Okay.
of the April 29th to.
Sure, let me hear
But a
this.
couple of things
Sure.
that I think that it would help if Your Honor would give us some encouragement to get discovery done. For example, I mean, essentially they have done little to no discovery to date at all. They have taken the wife's deposition of our vegetative client. They just set for Thursday, thinking we were possibly still going to mediation on Friday. Finally, the hospital's finance department about what these numbers are.
Okay.
So we need Your
That's
Honor to
fine.
encourage us to
Yes, no,
press
absolutely.
forward.
So here's what I'm going to do. I'm going to go ahead and cancel the mediation for Friday. I think that takes the pressure off everyone. Let's use Mr. Max for mediation, but let's mediate the first week of May. So at least that'll give you some time. Then you can get some more information on the excess carrier, follow up on that as well. Do you want to send interrogatories in terms of the coverage with the excess carrier or depositions? What would you like to do on the plaintiff's side?
Well, if we could get the affidavit that is A, proper.
Okay. Yeah, he agreed to do that. That's not a problem.
And B, addresses the issue of the $35 million in coverage referenced in the Form 10K, then we would be satisfied, I think, with those issues.
Okay. Is that okay? Will that take care of it?
Your Honor, we have been provided the 10K information.
Okay.
We have also provided them with a declarations page which shows that there's an amount of coverage in it for $35 million. We can't convince the plaintiffs otherwise that this $35 million in coverage does not exist.
Okay.
They are free to set whatever depositions they
And they
want
will do that.
with respect to who signed off on the 10K filing.
That's fine.
But I can't convince them otherwise.
No, that's fine. You've done what you need to do, so certainly, but I think this will give you time to short notice and mediate
But
deposition.
let's be clear, because what he's saying, what we've been told in this affidavit is that there's $30 million in coverage.
Correct.
So what I'm saying is that it's their coverage, it's his client's coverage. His client should know what kind of coverage they have.
And we have an affidavit to that effect.
That's fine. It's going to be in the affidavit then. Do you want to follow up maybe with?
Then we want to take a deposition.
Yeah, I think that'll resolve it.
So by week's end, we'll have a corporate representative to speak to the issues as disclosed in the 10K filing.
That's perfect then. So yeah, send it.
We'll provide them with a name by Friday.
That sounds great then. All right, great work. So then mediation pressure's off. I think that'll help both sides. And if there's any discovery you need my assistance with, set that for hearing. I'm happy to
And
help.
so just to make a couple of notes so that we've got the order right. So we're getting an affidavit in the correct form.
Correct, by tomorrow.
By tomorrow, by end of tomorrow. We are getting a corporate rep designation and a depot within 1 week.
Correct.
Depot name, I'll provide the name.
The name, yeah, but it probably won't be scheduled. At least the name within a week.
Okay, so can we get a deadline?
Depot, let's do within 30 days.
Okay.
So.
And then we're going to keep Mr. Max as our mediator, and we're going to get that done by, I think Your Honor said, the first week in May.
Yep.
Very good.
All right, sounds great. Thank you guys. Nice seeing you both.
Thank
you, Your Honor.
All right, let me go ahead and
They would
do.
be excused.
Yeah, of course. Have a
We'll
wonderful
submit
day.
the order electronically.
Absolutely. Have a great day. In which case you're here, Counsel?
Judge, can we recall the Marrero case? You granted the motion for summary judgment.
I did.
I was in front of Judge Kroll
Oh, no problem.
downstairs.
Come on up. All right, this is, yeah, that was the MSJ. What is the opposition to the MSJ?
Judge, there is an issue of material fact. They're alleging that there was an agreement between the
Did you
parties.
file anything? Because I didn't see anything in court file.
I did not.
Okay, I just want to make sure I didn't miss anything, because
No,
I saw
I did
no
not.
opposition.
Their issue, they filed the complaint alleging that there was an agreement between the parties that my client was not allowed to
Yes.
file a quitclaim deed. Our position is they gave her a quitclaim deed, she was allowed to file it. And in my affirmative defenses, which their motion says there are no affirmative defenses, there are affirmative
Which
defenses.
affirmative defense are you referring to?
The affirmative defense that I alleged in there was a statute of frauds, any conveyance of property needs to be in writing.
I understand, but then but technically it's still your burden. I don't have an affidavit. You can't just raise statute of frauds. I need something, I need, at least need an affidavit from your client alleging, or something legally showing how it was not in writing that it needed to be, and I would need an affidavit, and I have nothing, and it wasn't filed 2 days in advance.
Judge, can you give me some time to do that?
You need to follow the rules of civil procedure. The rules of civil procedure require that beforehand motion for summary judgment. Have a good day.
Thank you, Your Honor.
Thank you, guys. All right, East Coast Mechanical versus Heim, please. Motion to dismiss count 4. All right, good morning, guys. Do you have a court report?
No, ma'am.
Okay, all right. Good morning. This is East Coast Mechanical versus Heim, and this is a motion to dismiss count 4 of the complaint. And I read the motion, and I read count 4. You may proceed when you're ready.
Good morning, Your Honor. Brian Gottlieb on behalf of Precision. Again, it's our motion to dismiss, and if you've read it already, I'm not going to bore you with it. So the only thing I'd like to add is there's nothing in the complaint as to count 4 as to anything my client did improperly. They're strictly competing pursuant to the Wackenhut case, which I cited within there, which is 4th DCA says if you just have customers, it's free competition, and what's important is that interference isn't improper, and that's what caused it to not meet the 3rd prong of tortious
But let me
interference.
just ask you, what have they failed to allege from the tortious interference count? What element's missing?
Sure. And the element is actually element 3, an intentional and unjustified interference. And what the case law says is that it's not unjustified when it's competition and it's an at-will relationship. There's nothing alleged within the complaint that would state anything other than they have these at-will relationships with their customers. My client, Precision, is coming in. I understand the other 3 counts are completely separate, but my client has no relationship with them. They're free to compete, and just like in the Wackenhut case, we are able to go in and try to get business for ourselves. So unless there's something that is improper that we did, which there is nothing alleged improperly other than dealing with this former employee who has a non-compete agreement with them, but that's not on Precision, and Precision here on count 4 is being sued for tortious interference, and the case law says it's not unjustified, and that's why the 3rd prong fails. It's not unjustified when you have an at-will relationship, and all the complaint says is they have customers throughout the state. There's nothing that would give rise to anything other than an at-will relationship, which causes the count to fail.
Wonderful. Response, please.
Yes, Your Honor. Good morning. Robin Hankins on behalf of East Coast Mechanical. Counsel would be right, except in this context, he's wrong. And that's because the case law establishes that you can have an injunction based upon a tortious interference when a competitor hires one of our former employees who has a non-compete, who has provided confidential information, who had all of our customers or customer list, actually quoted this particular customer that we now found out that he has gone in and solicited business from post-employment with East Coast Mechanical. There's a case, Azar versus Leahy Corporation, it's a 2nd DCA case, that says that an injunction on the basis of a tortious interference is upheld where a former employee has solicited the plaintiff's former customers. There's also the Infinity Home Care LLC versus Amedisis case, where Infinity was a competitor that was sued for tortious interference when it hired a former employee who had a non-solicitation, non-compete, and allowed that employee to violate the non-solicit, non-compete to go out and solicit the former employer's customers. So those are the 2 cases. Wackenhut is in a posit, Your Honor, because primarily if you read the case, that case itself says this is limited to these specific facts. And it says that competition for business is not per se an actionable interference.
So you're not disagreeing with defense counsel's law, you're just saying it's not applicable to the facts of this particular case.
Correct, Your Honor. It was actually a backwards case, and in that case, Wackenhut had not sued the former employee, but when Wackenhut went back in and got the business, the former employee sued and said, now you're tortiously interfering with my customers. And the court said, no, we're not going to get involved in this purely business dispute. In this case, they actually hired our former employee who had a non-solicit, and they sent him in to our customer to get a quote. And that falls squarely within the 2 cases that we cited, Your Honor. And we have alleged facts in the complaint. I
Okay, so
know
you
you
want
want
this
the
to
copy.
no, I read that. Let me hear a rebuttal, please.
Quick rebuttal. They're not suing my client for injunction. So anything regarding the injunction is not pertaining to precision. Precision is strictly on a tortious interference count. And to say Whackhead doesn't...
Let me just ask you, in count
Sure.
3, the count 4, is it for injunction really versus damages on tortious interference? That's the only question, because I think you're exactly right on the law, Ms. Hankins. I just want to make sure the prayer for relief is, it's not damages, it's just injunctive relief. Against the,
It's damages. If you look at paragraph 32, it says ECM has suffered damages as a
So you're
result.
great, I think you're certainly entitled to the injunctive relief, it's just like, do those cases establish
Well, we
damages?
haven't moved for injunction, Your Honor, yet, but if you can get an injunction, then you still have a claim for damages.
I know, but that's not what those cases say. So all I'll do is I'll grant the motion to dismiss. All you need to do is just change that and just put, I would just go ahead and put equitable relief, and that way you can determine what you need to do then. You don't need to change anything else other than the wherefore clause.
Okay, if they want me to sue them for injunctive relief as well, Your Honor, we'll go ahead and add that.
Okay, that's the only change you need to make.
And then we'll file our motion for injunction.
Yeah,
get it
go ahead and file,
separate.
set that for hearing. I'm happy to expedite it. Just let me know how much time you need and how much time you need to just amend that one word in the per.
I'll get it done today, Your Honor.
Okay, wonderful.
5 days, I'll throw in the complaint.
Yeah, sounds great. Have a great day, guys.
Thank you, Your Honor.
Thank y'all. Let me go ahead and do Lusant versus Leonard, please. Counselor Whitty. All right, good morning. Nice to see you both. This is Lusant versus Leonard. Report. We do. All right, good morning. Could counsel please take their appearances for the record?
Gabe Zambrano, Zapatel Law Firm, on behalf of the plaintiff.
Charles Green, on behalf of the defendant.
Good morning. Nice to see you both. We have set for hearing this morning a motion to compel authorizations and plaintiff's objections to second supplemental request for produce. Which one do you want to do first?
We'll do the motion to compel
That should be
authorization.
straightforward. Is there any objection to the authorizations?
There is, Your Honor. There's no lost wage claim, and if you read the release, I have to ask you to read the release. It says that this release... more than that, the release is pursuant to 443, which is a statute I just looked at, .1715, which, unlike most statutes, does not provide or state that it says these records are confidential, and it doesn't say, which most statutes say, unless there's a court order or duly issued subpoena. These are...
Well, let me ask you, why are they even relevant if they're not seeking damage, if they're not seeking wages?
Because the plaintiff could have applied for wages due to an injury that we don't know about.
But they're claiming they did.
There is no lost wage claim, and I don't want to step on you, and I have to tell you, Mr. Zapatel represented this individual before, and we gave them those records for the prior crash. They know about the prior injuries. They know about the prior treaters.
Judge, but I agree that they're not making a lost wage claim, but those records can contain information which is relevant to the issues in this lawsuit.
Yeah, that's my only concern, because potentially if you made a claim on other bases, even though you're not claiming the lost wages in this claim, why not go ahead and produce the records but keep them confidential?
You have to read the release. He can't even sign the release the Florida Department of Economic Opportunity gave him. That release is tailored to a third party that's rendering a benefit to the
Can we
client.
use more of a standard authorization release?
Well, this is the release that they want, that the lawyer...
Just do it by court order then, instead of doing that. Say that the lawyer can use an order indicating the authorizations are granted, the information shall be provided, but not strike that language from the release, because I think it's a bit broad.
And kept confidential.
And kept confidential. So that way you'll get what you want to, and then it'll done pursuant to court order, and then they'll comply then. Oh, so the motion to compel authorizations is granted. Let's do the objections to second supplemental request to produce.
Okay.
And have you had a chance to meet and confer on the
Yes, ma'am.
Okay,
Yes.
wonderful. Okay, which items are remaining?
The objection number 1 to the marriage license.
Okay. Why do we need, what's the issue on that?
There's no wage, there's no consortium claim. She's not.
Why do you need a
listed.
marriage license?
It's a public record. You can get it.
Why is it relevant?
We just need to know the status of their marriage. That's what we
They
want.
didn't answer deposition or
It's a public record, and the wife was deposed about 2 weeks ago.
Okay, so that objection is sustained.
Okay, and the second one, we are seeking some personnel records.
Okay.
We're not seeking wage records, we're seeking personnel records.
That will contain medical information potentially?
No. Potentially.
Are you talking about number 2?
Well, number 3.
Okay. So our client, Mr. Louison, is a Haitian immigrant. He started a business. The business failed after the crash.
Okay.
He has no records other than the Sunbiz records, and he testified for, I think, 7 or 7 hours.
Just produce some biz records, if that's all I
We
said.
already did that, and he testified for 6 or 7 hours about this.
Are there any other documents related to the business at all in his possession, custody, or control?
No, and that was,
Well, then all he has to do is say,
Just say none.
none.
It's easy, just say none.
we gave him the Sunbiz.
Just say none, none,
No
just
more,
need
okay.
something in writing saying none. All right, next, please.
Judge, on the motion to compel, you want me to put in there the...
Granted.
Granted, and the court hereby orders...
They have to amend the response and put none.
Okay.
Absolutely.
Thank you, Your Honor.
Thank you guys, have a great day. All right, let me go ahead and do Brody versus Lyft, please. Counsel ready? Counsel ready? All right, good morning. Brody versus Lyft, or the court reporter. Good morning, nice to see you both. Can counsel please state their appearances for the record?
Todd Alofs for the plaintiff.
Eric Perez on behalf of the defendant Lyft.
Nice to see you.
May I,
This is motion, it's for the record. This is plaintiff's motion for sanctions and motion to compel the deposition. And you don't need to hand me this stuff. You should know my answers.
I know, I just do it if you
I read
have to,
everything.
Judge. They do it
The
too
other
long.
judges don't read it, but I do. Save your trees.
Thank you,
Okay,
Judge.
next. You may read your motion. You may proceed. I read your motion.
Thanks, Judge. This case, it's an auto negligence case. It's been at issue since November.
I know.
The only defendant is Lyft. Lyft produced documents that said that they provide coverage to the driver, Brandon Levin. We did a notice of depot with the original filings in November. At the request of defense counsel, 2 different, or maybe 3 different times, we rescheduled. Additional one time I had to reschedule because I was in trial in front of Judge Gill.
Okay.
We had set their guy first. Then they asked for the plaintiff's depot.
Sure.
And they wanted to do it the same day. So we rescheduled. I did.
I know.
At their request.
Okay.
So we had them all set for last week.
Got it.
All right. Plaintiff was set for 9.
Okay.
My 85-year-old plaintiff
Okay.
was set for 9 o'clock. I noticed, and I subpoenaed, because this gentleman in this firm does not represent Brandon Levin.
I know.
Set him for depot, served him with a subpoena. When he got re-noticed, I reserved it with
Got
a
it.
subpoena.
Okay.
They take my client's depot at 9 o'clock. Counsel apparently called my office after hours the day before, never spoke to him.
Okay.
He shows up for my client's depot,
Okay.
tells me I cannot do Brandon Levin's depot at 1 o'clock. Does not represent the guy. No notice of appearance. He's not a defendant. He's a witness. He's a driver in the accident. Clear liability. He blows a stop sign. My guy's on a main thoroughfare. T-bones him. My guy's got horrific injuries.
Got it.
All right. So I said, well, he's subpoenaed. He's not your client. We will start my client's depot at 9.
Sure.
When he shows at 1, we will take a break.
Got it.
And we will do his depot.
Okay.
His response is, counsel's, that I haven't had a chance to speak to now he's telling me he represents the guy, the driver. I haven't had a chance to speak to him. I said, you know what? Fine. Take an hour
Sure.
before the depot. Talk to him. His response to me was he couldn't talk to Lavin because he didn't have the contact information. It's on the police report that I attach as an exhibit to this motion. It's got the guy's phone number.
Okay.
All right. So at 1 o'clock, after 4 hours of my depot, of my client, Mr. Lavin shows up in my office for depot. He tells him to go home.
Okay.
Says, we're not doing his depot. Go home. Not his client. He files a motion for protective order. I got it at 1:09, 9 minutes after the depot was set. It's been an issue for 6 months, Judge. I've been doing this 30 years.
You don't need to say anything more. Filing a motion for protective order after the deposition said, I've never heard of such a thing. That's not acceptable.
Your Honor, I wasn't aware that I was going to be representing Mr. Lavin, the driver.
When were you told, and when did you file notice of appearance?
Why, he hasn't been named as a party, so there's been no notice of appearance.
Do you represent him? Yes or no?
Yes, I represent him.
When
at
did
this
you,
point.
when did you retain, when did
I was
you
informed the
retain?
day before. I tried to contact plaintiff's counsel. I spoke to someone at his office and informed them of the situation.
So why did
I
you
never
file a
received-
motion for protective order the day before? Why file it after the deposition started? I have never heard of this type of behavior. This is not acceptable.
Your Honor, I was trying to contact the driver the whole day before.
Why didn't you call opposing counsel and let him know?
I didn't call opposing counsel, as he just mentioned. I tried to call him the
Yes,
day
you have his
before.
email. Why didn't you email him?
Your Honor, I did email him and I tried to speak to him about the situation and he never returned.
When did you email him?
I don't know exactly the time. I'd have to go
You
back.
sent
and
him
find
an
records.
email indicating that you were retained by this gentleman the day before, so the deposition was off. Is that true?
I'm not sure exactly what the email says, Your Honor. I did try to call him and I do believe I emailed him.
This is not acceptable. We did not file a motion protective order regarding deposition after the deposition was supposed to start. I am sanctioning you in this case. This is not acceptable behavior.
Your Honor, the plaintiff's deposition was set for the same day. We began at 9 o'clock. We weren't able to finish until 4 o'clock. We wouldn't have been able to take.
That's not a legitimate
the
excuse. This is not
deposition.
professional behavior. I expect more of that from the lawyers in my division. I give you guys 100%, I expect that. If I allow you this to happen, then every attorney would do that in every single case, and this is not appropriate and not fair. And that's not the way we practice law in Palm Beach County, I'm sorry.
I understand that, Your Honor. However, the plaintiff has cited case law that provides a justification for his motion for sanctions. First one is out of the second DCA, and it cites if the party is thwarting discovery that their actions are sanctionable.
You did thwart discovery. You filed a motion to protect for after the deposition was started. That's not. There's no excuse for that. We do not do that.
I understand, Your Honor.
Why didn't you pick up the phone? Why didn't you call me? Anything. You don't file after the deposition set. You don't file a motion protective order and tell your client to walk.
Your Honor,
Would any lawyer in this courtroom want that to happen in their witnesses after they've prepared? No one would want that. That's not acceptable behavior.
I understand that, Your Honor. I tried to work out the issue with
Motion for
counsel.
sanctions is granted.
I provided 3 days this week, Your Honor, and he's indicated that he's unwilling to cooperate.
That's a different issue.
3 days
No.
this week.
That's a different issue on the scheduling. We're going to reschedule this at both sides. Meet and confer. They're going to get a date that works for both sides. But as for the past behavior, I am granting sanctions. Motion for sanctions is granted. Tell me the amount of your fees and costs for the time of the deposition and the preparation for your deposition. If you can't agree, we'll have an evidentiary hearing.
Your Honor, with regards to the preparation for the deposition, this deposition is going to happen anyway. I don't understand why there'd be a basis for fees for that. And I'm trying to work with plaintiff's counsel to give new dates as quickly as possible.
I'm
maybe
glad.
3
That's
this
wonderful.
week.
Let's go ahead and get the deposition set within the next 10 days. So we'll get the deposition set since you've been waiting. The next deposition hasn't set. Go ahead and grant the court reporter fees for the deposition and the time set aside for the deposition as well. If you can't agree to the hourly rate and the amount of hours, we'll have a separate hearing.
One thing if I could.
Sure.
The dates counsel's saying he gave me, because I don't want to go through this and have to come back, are tomorrow at 5:30, Thursday at 5:30, and Good Friday. I'm Catholic and I'll be in church. So
No.
I don't
Good
do
Friday.
depots on
No, we don't do
holidays
depots on
or
Fridays.
after
Those are
5.
holidays. So why don't we set the deposition next week during business hours?
Your Honor, my client doesn't have a way of getting around. He has an infant son. His wife is the only financial provider for the family. Basically, what he does all day is go with her to work and sit there and take care of their infant child. They leave at 5.
You can't send someone up to pick him up? He doesn't work, right?
He has an infant child that he takes care of while his wife is working. The child is a couple months old and needs to feed every 3 hours.
He's not feeding her, I'm sure.
No, but what he'll do is he'll go to his wife, get the child fed, and just continue.
Why can't the wife take the child to her work then? How does the wife breastfeed?
No, he goes to work with his wife, and he stays there while she's working.
Just the guy showed up for depo at 1 o'clock last week.
So
He obviously can be there.
Yeah, he can be there. Set this during business hours next week. All right, thank you guys. Have a great day.
I've got an order, Judge, a blank one prepared for you.
You guys need to fill it out before you leave then.
And then just reserve on the, if we can't agree. Thanks so
You guys
much,
have a good
Judge. You too.
All right, let's please go ahead and do East Coast Mechanical versus Hine, please. Motion for injunctive relief. Oh, we just did that one. Okay. Gonzazi versus Head, please. Motion for leave to amend. Sounds ready?
Your Honor, you called Buckner earlier?
I did. Are both sides here? Oh, come on up. Yeah, I didn't realize both sides were here. Come on up.
Alice Pettit on behalf of Tim Buckner.
No problem. Come on up, guys. We have court reporter and Buckner. Yeah, okay. This is Buckner versus Lotspeak. This is defendant's motion to continue. And I read your motion. You may proceed when you're ready, guys.
I had spoken with Mr. Carapuzzo. Neither of us are going to be ready for the trial period. He suggested, I think, October. I didn't even know if we needed to come to the hearing.
You don't need to. In my division, you don't need to. I try to make it as easy as possible for you guys.
We have no objection.
October? October it is?
Yeah. I have orders there. Do you want me to send a new trial order? Or do we
We're going to send you a new trial today by email. October it is.
Thanks so much.
Thank you, guys.
Thank you.
Here, Michelle, here's the case number. Take that off. All right, Bernie, we just did. Let me go ahead and do Guanziano versus Head. Motion for leave to amend punitive damages.
I'm here on that one, Your Honor.
There's no attorney on it. Yeah. On the punitives, anyone here on the punitives motion?
Oh, yes.
Oh, come on up.
Thank you.
And opposing counsels by telephone, is that correct?
Yes.
Let me give them a call.
Thank you, Your Honor.
Go Booze.
Yep, absolutely. All right. Is this Christian?
We're not.
And I'm getting the opposing counsel on the phone.
Hello?
Oh, good morning. This is Jim Sasser. I'm calling on Guanzino versus Head, and I'm trying to reach Attorney Schneider, please. Plaintiff's counsel?
Yep.
Oh, defense counsel, I'm sorry.
I'm Attorney Schneider.
Oh, wonderful. Good morning. We have a court reporter here. If you'd like to state your appearance for the record.
Okay, great. Terry Schneider, here on behalf of the defendant.
Counsel?
Thank you, Your Honor. Judge, is there a motion to amend at punitive damages? It's a DUI case.
I'm ready. Now, is there any opposition from defense counsel to the DUI case?
Yeah, because bottom line is under the statute.
Sorry, I can't. No, can you speak up? Wait, can you speak up a little bit? The court reporter can't hear you.
Sure. Under the statute, section 768.72, it requires that there's actual evidence in the record, or evidence that's proffered, and it's our position that counsel's motion is not verified, and there's no affidavit.
I need something.
No depositions, and so we're just saying that there's no evidence in the record.
That's fine. No, I agree. I just, on the punitives issues, the court's going to require, I need just an affidavit.
An affidavit by the claimant.
That's all I need.
Okay, perfect.
So what I'll do is I'll deny it without prejudice, but just refile it with an affidavit of your client. That's all I need. All right, thank you guys. Have a great day then.
Counsel, can I
Thank you. Bye-bye.
Alex on for the plaintiff.
All right, let me go ahead and do BAC Home Loans versus Shellhauer. Foreclosure case, BAC Home Loans versus Shellhauer. Motion to intervene? No? Okay. Marrero versus Schneider, please. Did that one already. Okay, Jones versus Malley. All right, let me go ahead and do the motion for summary judgment in, actually, you know what? Let me do Carter versus Goldman Sachs. That's telephonic. Let me do that. Actually, we'll wait on that one. Anybody else here for CMC or UMC? Otherwise, I have the 9:30. Come on up. Which case you guys hearing?
Your Honor, I'm on George Van Antwerp versus Kafka.
Sure. Is that a CMC or a UMC?
That's a UMC set by the plaintiff.
Sure. Come on up. Is anybody plaintiff here?
Plaintiff's counsel, no?
Okay, so we're not proceeding then. They're not here? Anybody else here for UMC? Come on up. All right, good morning, guys. What case you heard?
Good morning, Your Honor. We're on Ferreira, the MD now.
Oh, yeah, let's do the MD now. That's fine. Do we have court order? Nope. All right, you may proceed, counsel. I read your motion.
Oh, thank you, Your Honor. So I would like to add, in addition to what's in the motion, Your Honor, that we disclosed, story is that in January, we started requesting mediation dates per your trial order that was in October, October 19th by April 25th. So we requested dates after going back and forth and trying to get them to produce dates. Said, okay, well, we need to depose Dr. Kurse. Yeah. We said, okay, we scheduled a date. And then in March, they said, okay, well, we need to depose Dr. Baker. Okay. We disclosed Dr. Baker in September. Okay. So, and we couldn't get it scheduled. We think that, they have plenty of time to take this deposition. We want to move forward and make that comply with the trial order.
What do you hear, response, please?
Your Honor, Jessica Gleiberman for MD Now. Regarding that, we would like to take the plaintiff's expert depo prior to mediation, just so we...
That's fine, but can we at least have a case to move forward then? I don't have a problem with taking the deposition then.
Okay.
Yeah, you requested dates for the deposition?
We did for Dr. Baker, and I guess we haven't been able to reach a date on that.
Can we go ahead and give the deposition date and then we can get you what you need then, counsel?
Well, Your Honor, we tried, we gave them a date where we currently had another treating position set and we couldn't get it done. It's our position that we've had this excerpt disclosed for such a long time. They had an opportunity to do it, and your trial order's been there since October.
I know. We need to get this done. So let's do that deposition. But they need to be able to take the plaintiff's.
Our expert isn't available, I don't think, until June. And so it really kind of hampers. I mean, we even offered a telephonic at the time, a video conference.
But they have to be able to take the deposition. That's only fair before trial. What trial document are you guys on?
Our calendar calls April 25th.
So what this unfortunately is going to have a continuance unless the witness can be available. I can't make them go to trial without taking the deposition. Do you have another, is there any way you can do it after hours or anything with your expert?
We can try, Your Honor, but I'd like to mention, that they put themselves in this position.
I know.
I just want to move the case.
I know, and I definitely do, and I'll try you guys in April, I'll have to try you May, June, but they have to be able to be entitled to do the deposition then. And if you're saying the witness isn't available until June, then that's going to be an issue.
All right, we will try our best, Your Honor.
So that's fine. So I'm going to I'll keep you guys on the trial docket. I'll put you at the end of the docket. But in the meantime, I'm going to grant the defendant's request to take the deposition that they're requesting then.
Okay.
So that works then. Okay.
Thank you, Your Honor.
Have a great day.
Your Honor, the mediation deadline is April 25th.
Oh, let's push it back. Yeah, you guys can agree to it, just push it back. Okay. And you guys are going to be the end of the docket anyway. I special set everything. So it'll be toward the end of the 6 weeks. Let me know what weeks works for you guys best, and that's when the trial will be set.
Okay, thank you very much.
Thank you guys. Have a great day. All right, anybody else other than, you guys both sides here, both sides, team ready. Wonderful, come on up.
I'm on that side.
Okay, wonderful. All right, good morning, guys. Can you state your appearances for the record?
Chris Caproni on behalf of the plaintiff. And Louis Pater on behalf of Ernest, the defendant.
defendant.
Wonderful. And this is plaintiff's motion. You may proceed.
Yes, Your Honor. We're here on our objections and motion for protective order to aspects of their CME.
Sure.
We have an 80-year-old client with a brain injury.
Have you guys used the standard CME order that I use?
Because this, I don't know if Your Honor has one for neuropsychs. This is different. And they have,
Well, I've done plenty ones for neuropsychs before, so.
The one that I proposed to counsel, I've used before other judges. I don't know specifically if Your Honor has entered on that one, but specifically, they're taking issue with the means and method of doing the neuropsychological testing. According to the Board of Psychology, when they could sit in on the interview portion, but when it comes to the exam,
Yeah,
in order
no,
to
they
protect the
can't.
integrity,
That's the problem. They
yeah.
can't, because it's very confidential as to neuropsychs.
So they could watch it on a
The
one-way
window,
mirror,
the window, yeah.
or even the psychologist is willing to have a camera in the room, out of plain view of the examinee,
Yeah.
and they could watch it through a live feed.
That's
So that was
fair.
some of the objections.
Yeah, I'm going to go ahead and sustain defense objections, and we have to do it that way because that's what the neuropsych boards require.
understood, Your Honor. And the one issue, and I don't think this was addressed by that, they've noticed it to be two full days long.
Oh, that seems like a long time. Do we need 2 days on neuropsych?
Well, the reason why we do it is, first, given the age of the plaintiff. Second, typically the psychologist likes to do the interview portion on day one.
Okay.
Then, depending
Testing
on
on how long
fatigue-wise,
Okay.
then the second day is the
Okay. So it'll
examination.
be maybe 2 half days as opposed to 2 full days.
Yeah, the interview usually lasts about 2 hours,
Okay.
and then they reserve in the second day then to do the examination part of
So
it.
it'll be 2 half days rather than 2 full days.
Okay. Can we then maybe enter an order limiting the time period?
Yeah, let's do mornings on both days, so that way we know that the neuropsych eval will be shorter.
The other issue, Your Honor, they have asked us to enter into what's called a third-party observer agreement. It's not contemplated by the rules. Your Honor's already ruled on behind the glass. We're
Yeah.
okay with that. There's another provision in there that says that we're not allowed to use the transcript of it. We're not even allowed to receive it as attorneys. I don't think that's contemplated by the rules and is appropriate.
They're probably worried about the questioning, is that what
No,
we do?
so what it is the third-party observer agreement is any of the testing materials for the exam
Yeah.
can only be directly transferred to another licensed psychologist,
Okay.
so the plaintiff can't get it.
No,
And-
and that can go to your expert. Do you have an expert?
We do, Your Honor.
So we can send it directly to your expert then?
And we would agree for all the actual protocols, but in terms of the transcript that we have, that's something that
Yeah,
we should
the
be allowed to
answers,
direct.
the answers should be able to go to the plaintiff's counsel. The
Well-
questioning should just go to the expert.
So the argument as to why the questioning answers should only go to the expert, not to the attorney, is because it protects the integrity of the exam. For instance, if opposing counsel gets a transcript of the questions and answers,
I have a
they can use
suggestion.
it for other cases
All
and
right,
then
I have
prep
a
their
suggestion.
clients.
Let's send it to plaintiff's expert first, and that way plaintiff's expert, knowing the balance of neuropsychs, knowing what the board is, will share the questions and answers that are appropriate with plaintiff's counsel then, obviously, and we'll keep everything confidential that neuropsychs require to be confidential. But it should go to plaintiff's counsel first before, plaintiff's expert first before anything is shared with plaintiff.
And that's the same thing for the raw test data.
Yes, absolutely.
Because that's governed by the Board of Psychology.
No, absolutely. The plaintiff's neuropsych expert will know what the requirements are in the boards.
And I believe that's all.
I mean, the only other thing is, I mean, they wanted to limit the oral history. All that I would ask is, the questions that are going to be asked are just those to elicit information regarding the psychological condition,
Okay.
both present and past, because that is relevant.
Yeah.
She's not going to ask about fault. She's not going to ask about.
Yeah, no,
like-
don't get into the nature of the accident, liability, any of that stuff, but certainly she can ask a little bit of background because that will affect the neuropsych's opinion at the CME.
Okay, thank you, Your Honor.
Thank you guys, have a great day.
Thank you, Judge.
All right, thank you guys. Let me go ahead and do Carter versus Goldman Sachs and then we'll do the 9:30.
Welcome to Reservationless Plus conferencing. Enter your conference code, followed by the pound or hash. Sorry, you may have entered an invalid conference. Thank you. After the tone, state your name, followed by the pound or hash sign.
Judge Sasser?
Thank you. You will now be placed into conference.
Counsel, are you ready on Carter versus Goldman Sachs? Wonderful. I apologize for the delay. We had a lot of case management conferences hearings, and I saved the best for last. You guys are my last telephonic. What's the status of this case?
Your Honor, Richard Zayden, I represent the plaintiff, Nancy Carter. Your Honor issued an order staying this case until we arbitrate. And
Correct.
Not arbitrated. My client doesn't have an interest in going through the FINRA process at this time. I might suggest, of course, it's up to Your Honor, that Your Honor issue an order maybe giving a certain amount of time deadline by which to show that the FINRA arbitration has been filed.
Okay.
After which I would assume you would dismiss.
Yeah, and Mr. Zayden, that's what it requires. It's a FINRA case. I have to send it to FINRA arbitration. I don't have a choice. So with 30 days, I'll require it to go to arbitration within 30 days. Otherwise, the case shall be dismissed.
That's fine with us, Your Honor.
Is that okay with defense
Your
counsel?
Honor,
Yeah.
Yes, Your Honor, good morning. This is David Russell on behalf of Goldman Sachs. That's acceptable for us as well. It's been almost 9 months now since you issued the order, but I would request that if Ms. Carter decides not to pursue the FINRA arbitration, which is her sole forum, that the court dismiss with prejudice. We don't have to go through.
It will be dismissal with prejudice because that's a condition precedent. It's required. FINRA arbitration is exclusive forum. So the case, if it doesn't go to FINRA arbitration within 30 days, if a demand's not filed with FINRA, the case will be dismissed with prejudice.
Thank you very much.
All right. Thank you guys. Have a great day.
Thank you.
Okay. Coming up in the 9:30, Hannah versus Teeny Developers. Motion for summary judgment.
I'm on that, Judge.
Your Honor, may we work from the tables?
Sure. Wherever you want to. Fine. All right, good morning. This is Hannah versus Teeny Developers. Could counsel please take their appearances for the record?
James Ackman on behalf of the defendant, Hannah Development Corporation.
Jim Telephone for the defense.
Good morning, everyone. Nice to see you both. We are here on the motion for summary judgment. I had a full and complete opportunity to review the MSJ. I also read plaintiff's written response in opposition and the affidavit that was filed and all the materials in support of the MSJ. And Mr. Tobin, you may proceed when you're ready.
All right, Judge.
And in your argument, everything looked great in your motion. I just want you to address the written memo in opposition and the affidavit that was filed.
Well, to me, the affidavit really didn't say much of anything.
I know that's if you want to, but what do you want to address the memo?
Sure. All right. I'd like to address it by trying to take a 30,000-foot perspective of this case because I just don't know on what universe the plaintiff could possibly succeed in doing what it's trying to do. Basic facts are these. There's a mortgage on the property in 2006. It's recorded in the public records of Palm Beach County. Plaintiff and everybody else in Palm Beach County has constructive notice of the existence of that mortgage.
Sure.
So when 2014 rolls around and there's an HOA or condo association foreclosure and there's a sale and Hannah Development is the successful bidder at the sale, Hannah Development is imputed with knowledge of that mortgage and takes, subject to that mortgage, as a matter of
Sure, of course.
Okay. Then the roller coaster ride begins. The memo filed by the plaintiff in opposition to the motion places great emphasis on the fact that there was a certificate of sale and a payment made in conjunction with the foreclosure sale in the HOA foreclosure case, which without question occurred prior to the recording of the lis pendens and the filing of the foreclosure lawsuit by the plaintiff in the foreclosure action. Doesn't matter.
Why is that?
Makes no difference because, Judge, title is everything.
Okay.
All right. So the plaintiff has no interest in the property by virtue of a certificate of sale. The certificate of sale is not recorded.
Okay.
It's not a matter of record.
So you're saying this COS does not legally effectuate any transfer of interest whatsoever? It's a strictly the title that matters?
And yes, and I believe that goes without saying.
Okay.
That any conveyance of real property that's binding on third parties and that provides notice to third parties is required to be a matter of public record.
Okay.
And if you look at the complaint that was filed in the foreclosure case, I think it's important to note, and I have a copy if you want it, that the plaintiff sued the HOA, referenced not only the declaration, but the claim of lien, the lawsuit, and the lis pendens that had been filed in the HOA foreclosure, and asserted that its interest was superior to all of that stuff.
Okay.
And in the final judgment that was ultimately entered in the foreclosure case, which was never appealed by anybody, it provides that fairly standard language that the plaintiff, upon being conveyed title at the sale, or whoever is conveyed title at the sale, takes title with interest superior to all defendants.
Okay.
And anyone who has an interest in the property that arose subsequent to the filing of the list pendant.
Got it.
So when the plaintiff then jumps into that lawsuit a year later and files multiple improper motions for, first to intervene and vacate that judgment, denied, then a corporate pro se amended motion to do something, it's not really clear, denied. Then Mr. Ackley is back on the scene and files a motion for rehearing, untimely, right, okay, denied, motion for rehearing, granted, shortly before Judge Ferrara resigned his judgeship. And then Judge Lubitz enters her order. That's when my client gets involved, having paid approximately $170,000 for this property. We file our motion to vacate that order, and that was ultimately granted. Now, one of the interesting things that I want the court to focus on in terms of that order, keeping in mind that this plaintiff, I mean, they can say that that entire litigation is a figment of our imagination because they didn't file a pleading, and I'll talk about that.
Yeah.
But they never raised this issue there. They never came before the court in that case and said, you know what? This whole list pendants argument that Tullivan's making doesn't apply to us because we were a party in possession.
Let me just ask you, take you back, I gotta hone you in. The relief you're seeking is an MSJ. You're asking me to determine as a matter of law. That's what, I mean, you're making great factual arguments. Your history is on, procedural history is exactly correct. How do I determine this as a matter of law? That's my question.
Well, Judge, as a matter of law, I do think that there's collateral estoppel.
Okay.
The distinction between the Lucky Nation case and this case is in Lucky Nation, that party never sought intervention.
Okay.
All right, this party sought intervention.
Clear, that's undisputed.
There's lots of case law that I can provide.
But were they a party, and did they go through all that stuff? That's my problem. Like, collateral estoppel is obviously a very valid argument, and it's upheld on appeal all the time. But if I don't fall within the square four corners, it's hard for me to legally tag them with collateral estoppel. That's my problem.
Well, but they could have appealed the order.
But that doesn't preclude. That doesn't mean that you get summary judgment in this case because they are failing to appeal that order. That's my concern. Why do you get an MSJ because they sat on their rights, did not decide to do that? I think you raise great arguments, and potentially I could decide it. But my collateral estoppel is so. It's narrow and the elements are there. I need to hit every single element before I can legally decide as a matter of law that you're entitled to collateral estoppel. See where I'm coming from? That's my problem.
Let me focus on two things for your honor then. One is the list pendants argument. Okay. So set the possession issue aside for just a second.
Okay.
All right. So assuming that the list pendants is filed, you don't have to assume it. These are the facts. The list pendants is filed, then they get title.
Got it.
Okay. Those two facts establish that they have no rights to this property and are bound by the foreclosure judgment.
Okay.
So that's number one.
Got it.
Okay. And what I was trying to say before that kind of folds into this argument is in Judge Nutt's order, he found that it was undisputed that the plaintiff and its tenant were never in possession of the property prior to the list pendants being recorded.
Okay.
How can it, again, that order exists. The whole existential nature of
No, they can't ignore it, but the only question is legally, how does that apply in this situation to get you the MSJ you want?
all right.
That's my question. Okay, let me hear a response, please, Mr. Eichel.
Yes, Your Honor. I think this is an example of you have to be careful what you wish for. Honestly, my client tried valiantly to get into the case of the mortgage foreclosure.
Kept getting rejected.
And at every turn, we were opposed by the defendant in this case and the plaintiff in that
And if they
case.
had, they would have been a party and collateral estoppel would
And then
have brought
collateral
it
estoppel
up.
might have applied, it probably would have, but it doesn't now. My client was precluded from being in that case. We tried everything we could to raise to the court's attention the issues that have been brought before the court's attention here. And in fact, I'm a little bit dismayed that counsel for defense would suggest to this court that we didn't raise these LP issues to the court in the mortgage foreclosure. We certainly did.
You tried.
In multiple forums, we tried to get it before the court. And we were precluded because of the actions of the parties to the case.
Okay.
And I would also point out to the court that in the HOA case where my client obtained ownership of the property, at the time that the assignment of mortgage to the current purported owner of the note mortgage took place, which was July 31st of 2015, at that point in the HOA case, the purported assignor had already been defaulted, final judgment had already been issued, and a judicial sale had already taken place.
It was too late.
So my client purchased from the party that had putative ownership at the time of the default and of the final judgment. Afterwards, they tried to transfer it off, but they'd already lost their interest.
Okay.
So here we are with what I believe to be a very straightforward case of a valid argument for quiet title, and defense is trying to obfuscate the issues and the facts to the point where to mislead the court, frankly.
Okay. All right.
The Bevins case, if you'd like a copy, I have it here.
I read everything.
And the statute itself, with regard to Judge Nutt's order, the statute itself is very clear, except for the interest of persons in possession.
I know.
And then it goes on to state the facts that counsel relied on in his arguments in the mortgage foreclosure case.
Okay.
Judge Nutt misinterpreted the facts and misunderstood the facts and ruled as he did. I can't change that.
You can't touch that.
But it doesn't control here in this case. We can show this court the actual facts, which we've done in the affidavit. There are clearly, with regard to the assertions by the defense, issues of material fact. However, my argument would be to the court, I think that the facts before the court are clear. There's no dispute as to the facts that would support summary judgment for my client.
Okay. Well, you didn't file cross motion.
We did not. We did not.
Okay, all right, let me hear a rebuttal, please.
Sure, Judge. A couple of cases. One is the Whitburn case. You may be generally familiar with it. I've got copies for you and for counsel. 197 3rd 1087, a second DCA case from 2015. That was a case that was interesting and similar to this case in that a person who's similarly situated as the plaintiff in this case filed a motion in a foreclosure, but not a motion to intervene.
Okay.
But it was treated as a motion to intervene because of all the arguments that were made along the way. And one of the holdings in this case is that an order denying a motion to intervene is appealable. And it also, the court held, citing other cases, that the order is a final appealable order because even though it was entered after the final judgment of foreclosure, it was dispositive of the issue of Whitburn's standing.
No, and I agree with you. It might potentially be a final appealable order, but that's not the issue in this case on your MSJ, though. Just because they chose not to appeal any of the orders denying the motion to intervene does not hold their feet to the fire in terms of that their collateral estoppel applies. That's what.
But, and I hear you, but the order also determined, and here plaintiff is collaterally attacking that order. Judge Nutt didn't understand this, and Judge Nutt didn't
Whatever, that's a
understand that.
different issue. Okay.
Judge Nutt entered an order that said the list pendant statute applies. Their claim, having arisen subsequent to the list pendants being recorded, is forever discharged. That's it.
Okay.
They could have appealed that order. And just one more quote from the Whitburn case. where an order after judgment is dispositive of any question, it becomes a final post-decretal, D-E-C-R-E-T-A-L, order. To the extent that it completes the judicial labor on that portion of the cause after judgment, it becomes final as to that portion and should be treated as a final judgment. That's my point on their failure to appeal. That's one thing. The other thing, and this is an interesting case that I didn't cite in my paper, so I'll give you a copy.
Sure, I'll take it.
Mr. Ackley a copy. It's called Portfolio Investments Corp. versus Deutsche Bank, 81 Southern 3rd, 534.
Mark, can you grab that case from council? Thanks.
A third DCA case from 2012.
Thank you.
And the facts are nowhere near the same, Judge, so don't get me wrong.
That's fine, I'll take a look at it.
All right, but essentially, this was a case where a third party in a foreclosure never intervened, but participated in the case to a tremendous extent. And then on appeal, the other party on the other side says, well, that party has no right to appeal because they were never a party to the case. And the court basically said, look, under the facts of this case, you can't deny that that non-party, in quotes, had full participation in the litigation, was bound by the judgment, and should have a full right to appeal.
But here, there wasn't a full participation. That's my problem.
But there was. They participated for over a year, Your Honor. They filed motion after motion. They appeared before this court on multiple occasions. They retained possession of the subject property for over a year, collecting rents, fighting tooth and nail to keep my client, who paid for the property, to get possession, and now they're taking a second bite at the apple. To me, this is a gross abuse of process.
And it may well be, but I don't think the motion for summary judgment is appropriate legal. So the motion for summary judgment is denied. You can file your separate motion for summary judgment. Otherwise, maybe
Well, don't do it yet, because I'm going to be asking the court to amend my pleadings, because the one thing that I know I can do is re-foreclose.
That one's easy.
Well, it would be easy. I just think it shouldn't be necessary.
No, that's fine. If we can do it for re-foreclosure, get it done, get your affidavits in, and then wipe this out, underline, and then wipe up.
All right, then can I consider my Ori Tennis motion to be granted?
Any opposition to motion to amend?
No.
Okay, so I'll do that. How much time to file the written?
10 days.
10 days it is.
You have 10 days to respond after.
Yeah, absolutely. So, Mr. Tallman, I think that's a legal way to do it, and that way we can get you in 20 days, 21 days on your summary judgment, and that's the easy way to do it then.
All right, do you want me to prepare one big order?
Yes, yeah, one big order denying the MSJ, but granting your motion or tennis motion for leave to amend, and we'll deem it filed as of tomorrow then. Coming up on the 10 o'clock if both sides are here.
Blank here.
Oh, you do now? I can do that, whatever works.
Yeah, it'll just take me a second. I'll just have to sit here.
All right, let me have the 10 o'clocks come in. They're going to take a little longer, and I think they may have some witnesses. I don't know if they're talking outside. It may be.
Thank you for your time.
Thank you, guys. Have a great day. Are you here at 10 o'clock, Madam Clerk? You're here at 10, okay.
You need me out of the way, Judge?
No, that's fine. They're going to go ahead and get set up. I'm going to ask them how much time they need. There's the evidentiary. Coming up on the 10 o'clock, guys. Let me find out how much time you need, and then we'll give council a few minutes then. Good morning. We are here in Flanagan versus Ginsburg at MD now. I just need appearances from the record. I need to ask council how many, are you going to have any witnesses for the hearing or not?
No.
No, okay, just legally, okay. Let me give you guys about 2 minutes, and let me just have Mr. Tellman finish his order, and then we'll get started.
Sure.
Take your time.
Okay.
Just let me know when you're ready on the 10.